Welcome, gentlemen. All right, so we're ready to proceed. And just to remind you, 30 minutes apiece. And Mr. Watson, if you let me know how much time do you need for rebuttal, up to 5 minutes. And so with that, we're ready to proceed. Go ahead, sir.
Yeah. With the court's permission, I will ask to reserve 5 minutes, Your Honor.
Very good. Thank you, sir.
If I may proceed?
Yes, sir, please.
Your Honor, it's a sad reality that at times a child sees their elderly parent experience decline in eventually their physical being, but also their precious mental faculties. And there are times where a child worries that their parent could be the victim of exploitation, neglect, or abuse. And we have a system designed to protect those people. We have the guardianship statutes, and at issue in this case is a couple of departures, I would say, from the essential requirements of those statutes by the lower court. In particular, I'd like to...
The way you phrased that departed from this, are you saying this is a cert petition that you're really bringing before us, or what is this? What is our jurisdiction here? What is this we're looking at?
Well, certainly the jurisdiction has been debated by the parties in their briefs, and this order entered by the court is an injunction. I know
how so? You usually, because an injunction is an extraordinary remedy, and usually when a trial court means to enter an injunction, they say this is an injunction issued pursuant to this. There's certain factors that there's factors the court has to consider. It has to make findings of elements. How is this order that just says, look, the information has to be requested, not offered? How is that an injunction, as that term is typically understood?
Well, I certainly agree that a court should make all those findings and should be able to check all those boxes before entering what is essentially a gag order, and also which goes beyond not just telling the parties or their attorneys that they are prohibited from speaking to the examining committee. You know, imagine my dilemma when they are calling my office, requesting copies of the petition and wanting to hear the background, which is typical in these matters. And I'm not allowed to even say, I'm not allowed to talk to you.
See, here's the thing, counsel, that kind of order, you know, as soon as I read this, I was thinking by your argument, by the lights of your argument, every time a trial court sequesters a witness or tells lawyers do not talk to jurors or potential jurors outside of the voir dire, that's all an injunction now. Or an order in limine becomes an injunction. That clearly can't be the case. So why is what we're facing here more like a traditional injunction under your argument, and less like what initially struck me is that, well, it kind of sounds like a sequestration?
Well, this order is not just in the nature of an injunction. I would maintain that it also, because it departs from the essential requirements of these guardianship statutes, there is no effective remedy on appeal. And so we're forced, as the facts have borne out, we have two examiners that came back no incapacity. We have Dr. Diamond, who was the only one to be able to reach out and talk to family members or caregivers that gave his report. And in his report, he finds that there is, in his professional opinion, vascular dementia. And so the way this case is postured, the court would be forced to dismiss this guardianship proceeding because of the ill-advised procedures which it uniquely set up in this case. So whether it's an injunction or whether there is no remedy on appeal, I think there is jurisdiction here. And to look at those reports.
The trial court's order, it strikes me, is really saying, I want you to follow the statute. And merely saying follow the law is not injunctive relief. And there's, as I understand it, the examining committee can, of course, seek out whatever information it deems appropriate, right?
Well, if they knew that they were allowed to do that, that might actually be an orderly procedure. But the examining committee was prevented from knowing about this order, which supposedly set forth a new process for addressing the incapacity of the person. They
But
were
does it
prohibited.
does it limit what the committee can do? It really limits what the family members can do.
Well, I would say it does both.
The statute contemplates, am I not right, that the members of the committee can reach out to whatever sources of information they deem necessary or appropriate.
Exactly. And that's why the petition is an essential part of the information which must be given to the committee. The cases that have been cited by both sides, for instance, this Cook versus Cook, which is very instructive, the committee, the medical doctor, he interviewed Cook, and he also spoke with the social worker, another member of the examining committee, Cook's brother. He reviewed the petition, police reports, the medical chart. The other third member, the licensed psychologist, the case says he reviewed medical records. His examination included review of the guardianship petition. He spoke with brothers and consulted with the primary care doctor, and same with the other member of the examining committee. Spoke to family members, spoke to friends, social workers. This examining committee was kept in the dark who these people were. They were not permitted to know who the next of kin were. They were not permitted to know that this man had had a caregiver every day of the week because he needed one, and that this caregiver had observed many concerning activities. You know, to say that, well, you have the right to eat and drink, but we're not going to let you take a bite or have a sip. You know, if he has a right to be comprehensively examined, and our courts have, you know, for instance, the second district in the McKinney versus Rawl, the proposition there is that benefits the ward to have the most accurate information available to the committee. And here, the most accurate information was denied the committee. And the committee, if Dr. Diamond hadn't been a proverbial Sherlock Holmes and in part of meeting there and just kind of looking around to see, which examiners do, what the living conditions are and are they appropriate and safe. And he noticed on the refrigerator the telephone numbers for emergency contact, and it listed the caregiver and it listed the daughter. And so, but for that fortuitous event, he would not have spoken to the daughter. He would not have spoken to the caregiver. He would not have been aware of why they believed this man was subject to exploitation and had incapacity. The other examiners weren't as fortunate to do that. And so you have two reports that were uninformed. You have one report, and it is very informed when you read the doctor's report.
But those alleged defects are subject to being dealt with in a subsequent hearing on incapacity. Isn't that correct?
Not under the statutes, because there's been two reports finding no incapacity. The court is required to simply dismiss. I don't know that there's any authority for the court to continue when there's a statute that says you shall dismiss the proceeding. And therein lies the catch-22 dilemma. These reports have to be filed within 15 days. They were all promptly provided. And there you have it. Dr. Diamond notes that it was almost impossible to do his job because of the restrictions on the information available to him. His opinion proves the case, essentially, that the petition is an essential part of the information that a committee must have. You see that in the Cook case and this other, the Wallace case. When you read that opinion and look at what's going on, they said, okay, we're going to prohibit you from attaching medical records to the petition. That was the big issue in that case. And the court went on to, in its opinion, I guess starting on the 5th page, where it lays out the exact language of 744.3201, petition to determine incapacity. And they even bold the subsection D and E. So it's sending a message that this is very important. And at D and E, it talks about the names and addresses of people with information about the incapacity and the attending or family physician. In the opinion, the court writes that, okay, we're not going to allow you to attach these confidential medical records, which most people don't have to begin with anyway. but they had it because there was trust litigation pending. And in that trust litigation, those records had been produced in discovery, and there was an existing order that said, keep these confidential. So in an abundance of caution, the attorney says, you know, we have a belief that this person's incapacitated, and we're looking at filing a petition. And so even with no guardianship pending, the court enters orders about how to handle a case that's yet to be filed. But in their reasoning is that, look, we're going to make sure, if there is a guardianship, that you're going to comply with 744.3201. And the person filing the petition will be required to state in the petition to determine incapacity if he believes he's incapacitated, specify the factual basis and belief, and provide the names of persons known to him who have knowledge of these facts through personal observations. And the court goes on to observe, thus Mark, who is, they're using first names in this case, will be able to state in the petition that he believes that his father suffers from frontotemporal dementia. Mark will also be required to set forth in the petition the name and address of Milton's attending or family physician. Mark will be able to state in the petition to determine incapacity that Milton's physician is Dr. Dura of the Wine Center for Alzheimer's Disease and Memory Disorders. And based on that information, Mark can provide in the petition to determine incapacity. The 3-member examining committee will be apprised of Milton's alleged dementia and the name of the physician. So these cases just assume that the petition, and everybody in practice that I'm dealing with, that petition is provided to the examining committee, and it's not a requirement that is spelled out that you have to give it, but it certainly needs to be implied. And there's not any cases that I've ever found that said they're prohibited from this information. To do otherwise makes them try to engage in a game of hide and seek and guess what the truth is. This is not the way a comprehensive exam can be accomplished. So we would have to maintain that the court's order, which prohibited the examining committee from having a copy of the petition, was just something that couldn't be remedied, on final appeal. The committee's reports bear out our worst fear, and that is, if they don't know who to speak to get the context and the background information, which Dr. Diamond in his report makes clear, it made it almost impossible for him to diagnose, because the alleged incapacitated person here is high functioning in some regards. And he's also, as the doctor said, an excellent confabulator, which means at times he lies and doesn't know it, or he lies and doesn't care, because he's very convincing. And so for someone to go in there and have no background or context or whatever, they could easily be fooled. I've got wards that I have lunch with, and they're very pleasant, and strangers could come up and talk to them, and they would not know that this person's incapacitated. And so the ability, I've often explained, long-term skills are back here. Short-term memory is up here. And those long-term skills include social skills. And they're often the last to go, especially if the nature of your dementia is more affecting your short-term memory. But you need both to be able to function and to make excellent or appropriate decisions and have judgment and to be able to function in society. And so what we have is someone who has social skills. He was very intelligent. He was college educated, and he has those social skills. And so when you have an examiner not knowing what the alleged problem is, they're going to meet with him and he's going to present well. But it's not designed to be that way. The Supreme Court in our Hayes versus Guardianship of Thompson says these are not adversarial proceedings, and the overwhelming policy is to protect the ward's interests, not to make it hard to become a ward in a guardianship, but to protect their interests. And that's borne out by the second district's opinion in McKinney versus Rawl.
And
the
if
ward benefits.
Mr. Wascom, you're approaching your 5-minute rebuttal. You're free to go forward if you'd like, but I just wanted to alert you to that.
Thank you. Well, let me touch on one other subject that I think is just fundamentally at the heart of this, and then I'll reserve what little time. The court made the medical records off limits, and that's not what 730 or 744.331 contemplates. The only thing that the ward or the alleged incapacitated person or their attorney has a choice of not giving up, so to speak, or volunteering are social and psychological reports. And those have always been a very special category. We protect the confidentiality because people will not want to go meet with a psychiatrist or engage in therapy if they think that their secrets are going to be divulged to the world. And so the court's reading of that statute to the effect that now the alleged incapacitated person is the only one who can say, you get to look at my medical records, that's incorrect. And that again caused the problem here because the first thing they did was tell the doctor, you don't volunteer anything. And if these people call, we want you to recant your last opinion. And you're certainly not going to give them that letter where you certified your belief that he was incapacitated. So we have the examining committee being kept in the dark about all the valuable information that's mandatory in the petition to determine incapacity. And then going beyond that, the court orders that the medical records not be available to the examining committee. This is not how guardianship incapacity proceeding is contemplated under the statutes or in support of the policies set forth by our Supreme Court. So I would reserve whatever time I have, Your Honor.
All right. Actually, you have just about 3.5 minutes left. All right. Very good.
Thank you.
Thank you, sir. And can I trouble you, Mr. Watson, to mute your microphone? And Mr. Butler, I think you're all set to proceed. Thank you, sir.
Your Honor. Good afternoon, Your Honors. Good afternoon, Mr. Wascom. I'm Jesse Butler of the law firm Dickinson and Gibbons in Sarasota here on behalf of the respondent. If it may please the court, I think the issues have been briefed very well, and I know Judge LaRose and Judge Lucas brought up two of the kind of seminal issues I raised, which is jurisdiction in this case. Because this is not an injunction, it's a discovery order, it's a motion in limine. If this was an injunction, then any order granting a motion for protective order would be subject to immediate appeal as an injunction because somebody was protected from having to produce documents. The issue in this case is not whether the examining committee was not allowed access to records. It was whether the petitioner was allowed to cherry pick and supply records to the examining committee and to engage in ex parte communications. The judge was very clear.
And I'm curious, Mr. Butler, because I pulled up the transcript. Didn't the court give an opportunity for counsel to even come back if they requested more information or if they objected to some of the items that would be provided?
Absolutely, Your Honor. And that pertains to whether there's an effective remedy on appeal. But the judge not only orally pronounced it, but it's in the order that if the parties aren't able to stipulate and the petitioner still wants to interject herself into providing documents, then they can go back to court and file a motion and ask the court to consider that. And oddly, the petitioner in this case instead chose to file this appeal, wait until the examining committee reports came back, and then actually did file the motion to ask the court to allow her to provide the information to the examining committee. And that's in the appendix that was filed with the answer brief. But that exact relief was requested. So I found it interesting. I know Mr. Wascom noted that there's no remedy because this case has to be dismissed under the statute. Well, obviously, Mr. Wascom thinks there's a remedy because he in good faith filed a motion after all three reports from the examining committee came back, asking the court to allow him to, on behalf of the client, provide additional information to the examining committee and have them consider that before their report was final. So he clearly thinks that there is a remedy available. But the issue in this case has been, I believe, pretty squarely addressed by at least two cases, both of which upheld nearly identical rulings as the method and order that was issued in this case. The first was the Lindy case. And the Lindy case was a situation where the ward filed an emergency petition for injunction, and that was specifically for an injunction to prohibit ex parte communications between the temporary guardian who had been the petitioner, and an examining committee member. And the petition for the injunction alleged that the temporary guardian had interjected himself and had inappropriately provided documents and had influenced the examining committee member. And it's interesting because that's pretty much procedurally what happened here. Is before court-appointed counsel could get involved, the petitioner's counsel had interjected, spoken to, or provided documents and a letter to the examining committee members. And when that was discovered, the objection was raised. But oddly, in this case, in the instant case, the petitioner is actually the one who filed the motion to appoint a new examining committee member. In the briefs, counsel says, well, we just didn't want to fight about it. But I think it's important to note that the petitioner requested the relief of a new examining committee. And they asked for instructions. And in their petition or their motion for instructions, she does not ask for specific relief. She's just asking for guidance. She doesn't say, this is a motion to provide documents 1, 2, 3, and 4. It's just a motion saying, hey, I think this should be a comprehensive examination. I want guidance on what you think that is. In the Lindy case, on appeal, the court specifically says, the temporary guardian asserts that the trial court's injunction impermissibly prevented the court-appointed independent physician from having access to and considering all relevant information regarding the ward. And that's a quote from Lindy. That's the exact same argument as being presented today. And the court in Lindy rejected that argument. And with regard, they first addressed the issue of what is the appropriate standard of review, because I know in the briefs, the petitioner has argued that, well, this is a de novo standard of review because it has to do with whether the judge applied the correct law. It's a creative argument and one that was addressed by the Lindy court and rejected. In Lindy, the court specifically said, while the temporary guardian concedes that the trial court's ruling on Ward's motion in Lemonade is reviewable because there was a motion filed in that case as well, the temporary guardian suggests that we employ a de novo review of the injunction. Temporary guardian argues that the trial court erred as a matter of law in limiting his interaction with the independent physician appointed to evaluate Ward. Temporary guardian posits that as a practical matter and presumably as a matter of law, a physician provided with more information renders a better opinion than a physician provided with less information. That's the exact same argument being promulgated by the petitioner here, that, well, don't we all want this to be as comprehensive as possible? Doesn't it help if we just give the doctor as much information as we can? Well, maybe that's true, but as the court in Lindy said, this argument, quote, ignores the distinct statutes involved in the relevant guardianship determination and disregards the fact that the trial court lawfully sequestered the independent physician while establishing an orderly mechanism for providing information to the independent physician. That is exactly what has happened in this case. And I don't think that the petitioner has done enough to distinguish how the holding in Lindy is any different than what happened here. You have a situation where the petitioner argues the more information, the better. I think that the names of witnesses should be forced upon the examining committee. We should spoon feed the examining committee members documents that the petitioner thinks are relevant, rather than, as the statute requires, allowing them to perform an independent examination. And the statute itself, I know there was a lot made in the brief about the term comprehensive, but the statute 744.331 at subsection 3F defines what a comprehensive examination is. It says the comprehensive examination must include a physical examination, a mental health examination, and a functional assessment. It's defined in the statute, and there's no argument here that a physical examination didn't occur, a mental health examination didn't occur, or a functional assessment didn't occur. It's argued that, well, to carry out the legislative intent of comprehensive, we should give more information to an examining committee, but we're not here. There's no reason to get to legislative intent when you have an unambiguous statute, which, as we point out in the briefs, that there is no ambiguity. The Cook case, which is a 2018 case from the 4th District, held that this statute is unambiguous and must be strictly followed by its plain language. So there's no reason to be stretching our imagination as to whether the legislature meant for additional information to be provided. The statute says what has to be provided, and then the examining committee may go out and get additional information. The same issue was brought up, or essentially the same issue was brought up in the Wallace case. In Wallace, the court held if the legislature intended that the person filing a petition to determine incapacity must be permitted to incorporate into the petition the AIP's medical records and the written reports issued by physicians that were hired by the petitioner, the legislature could have easily incorporated these provisions into the controlling statutes. The legislature, however, chose not to. It is not the function of this court to expand the controlling statutes by concluding that the petitioner must be permitted to attach these documents to the petition to determine incapacity. And then the court goes on one step further and says, not only can these documents not be attached to the petition, but then the court says that it upheld the ruling that parties other than the AIP and counsel cannot have ex parte communications with members of the examining committee. And the court says that the trial court was most likely concerned with the effect that the ex parte communications would have on the members of the examining committee. Thus, we find no error in imposing such a limitation. So in both in Lindy and in Wallace, you have situations where a petitioner makes the argument that, hey, I should be able to interject to the examining committee what I think is the relevant information that will help them in their assessment. And trial court said, no, this is supposed to be independent. You're not going to interject yourself. And it was upheld on appeal. So I think that this is a situation where, one, there is no jurisdiction. This is not an injunction. It's an order sequestering a witness. It's a discovery order, however you look at it. If this is going to be considered an injunction, it would have to satisfy the Miami Heat test, which, one, you'd have to show that this has the practical effect of granting or denying an injunction. And the Judicial Watch case, as I think Judge LaRose was alluding to, held that merely requiring compliance with a statute is not enough under 9.130 to satisfy the Miami Heat test. And that's what the judge here did. The judge is requiring compliance with the statute. If in looking at the actual order, the order regarding appointment and examination of the AIP by the examining committee, which is at the appendix item number 5, all that the order really does is paragraph 3, which is the first paragraph that the petitioner takes issue with. It says that if the AIP's primary care physician is available, the committee member shall consult with him. Well, that is directly the language in 744.331 3A, which, to quote the statute, says if the attending or family physician is available for consultation, the committee must consult with the physician. That's the language that the legislature used. It doesn't compel the physician to reach out to the examining committee member. It doesn't say it has to happen. It says if the examining committee member chooses to reach out and they're available, that they must be consulted. And that happened here. And we know that Dr. Diamond reached out. So we also have number 2, the examining, back to the order at issue, under paragraph 3, the second sentence, the examining committee may consider examinations, psychological, psychosocial, and similar reports voluntarily offered by the AIP. And that comes from the statute, this time at subsection 3E, which says, in addition to the examination, each examining committee member must have access to and may consider previous examinations of the person, including the other types of records referenced in the order. So paragraph 3 just copies the statute. And paragraph 4 establishes the procedure saying, hey, if the petitioner has additional information that they want to get to the member, file a motion and we'll have a hearing on it. That didn't happen. And item number 5 is simply making very clear that this order is not intended to to somehow box in the examining committee members. It says that if during the examination an issue comes up that the examining committee member wants to investigate, they can do so without order of the court. And clearly, Dr. Diamond wanted to go out and do further investigation, was able to do so. Essentially what the petitioner is taking issue with is he just thinks that the first two examining committee members, he doesn't like their opinion. He thinks it's an issue that, well, they should have gone out and done more, but they've followed the statute. They have to be trained. The statute sets forth what they have to do to become certified. They know from the order appointing them, which is appendix item number 3, it says in there what the alleged incapacity is. It says what who the primary care physician is. And that order was provided to the examining committee members, and it's clear, this is the order they got. And the order is a standard order. It just says the committee shall examine the alleged incapacitated person in accordance with the standards set forth in Florida Statute 744.331. And it even says that they shall have access to any records voluntarily offered by the parties. So the order actually appointed and given to the examining committee members is clear that you're not being curtailed. There's no reason for them to believe they're being curtailed. It's the same examination that they should otherwise have. As we brief, I think the first thing is the court has to determine whether it has jurisdiction. I don't believe it does. This does not qualify for interlocutory review as an injunction. Even if you treat it under the Miami Heat test as factor one, maybe, if the court for some reason decided to have the practical effect of an injunction, which we dispute because the case law makes clear it doesn't, you'd have to show irreparable consequences, which don't exist. The petitioner is the one who requested these instructions, and the court established a procedure to provide the information to the examining committee members, which she did not do. And it can be challenged on plenary appeal. This isn't a cat out of the bag discovery order. There's nothing that's going to happen that would prevent this case from being reviewed on final appeal. If the court decided it did have jurisdiction to review this, then the standard is clearly abuse of discretion, and there is no abuse of discretion. The Lindy court and the Wallace court make clear that the court had the discretion to enter the discovery order that sequestered the witness and protected their independence. And there simply is no error. There's no harmful error here. The petitioner alleges the examining committee was prevented from contacting the petitioner and caretaker. That's simply not true. Dr. Diamond contacted the petitioner. Dr. Diamond contacted the caretaker. It also, as a matter of just logic, in any guardianship proceeding, there's always going to be a petitioner. And any of the examining committee members can simply find out who the petitioner is, ask who filed this petition, or they may choose to conduct a conversation with the petitioner to get their side of it. But that's up to them to choose whether they want to do that. The statute does not mandate that they talk with the petitioner or allow the petitioner to call the examining committee member. The final point, which was briefly touched on by opposing counsel, is the issue of the sealed records. And first of all, there's no preserved error with this. The transcript below is clear that when the request was made to seal the underlying records, there was no objection by petitioner's counsel. In the reply brief, he says, well, there wasn't time, but there was quite a bit of conversation about that. Petitioner's counsel interjected about other things, never objected to the sealing of the record, didn't object to it when the court made the ruling, didn't object to it at any time before the hearing ended, and to in retrospect, wish that he had done so is not appropriate for appellate review. Moreover, there's also no harm in sealing the record that is subject to, even if it was preserved, interlocutory review. That's not the kind of order that is subject to review under 9.130. And what essentially petitioner is arguing is that the examining committee members should have had access to the, quote, reports, end quote, of the original committee. but there was no report because there was no examination. All three of the original examining committee members, if you look at their reports, which are attached to the appendix, all three of them said, I didn't examine the AIP. I have no opinion on anything. Everything is NA or no exam, no examination. And again, the petitioner filed a motion to appoint a new examining committee. So the idea that there was some error in not allowing the examining committees to review the reports of the original committee belies any idea that there could be harmful error there, because there's nothing in those reports other than notations about what the petitioner, conversations, the ex parte conversations. It's just a backdoor to get ex parte conversations in.
And Mr. Butler, you're getting close to the very end, sir, if you want to wrap it up.
Yes, Your Honor. So in conclusion, we would ask that the court deny or dismiss the appeal for lack of jurisdiction, or in the alternative to deny the relief requested by the appellant in this appeal.
Very good. Thank you, Mr. Butler. All right. Now, Mr. Waxman, I think you have about 3.5 minutes, sir. Okay.
Yes, thank you, Your Honor. First of all, with regard to jurisdiction, if the Wallace Court was able to exercise jurisdiction, there's certainly jurisdiction here, because the order on appeal is essentially the same order that says, I'm prohibiting ex parte communications with the examining committee. So to the extent the Wallace Court had jurisdiction, certainly this court does. Next, with regard to Lindy, that was a different creature of the statute. That was a restoration to capacity. And there, that examiner is allowed to see the prior exams. Here, we had a judge who entered an order that says, you don't get to look at any medical records. Well, Lindy was a restoration. There, they got to see some medical records. And here, our committee did not, because they weren't volunteered by the alleged incapacitated person. Now, back to the original court proceeding, I filed a motion and filed the concerning emails and the concerning caregiver notes, and asked the court to include that in the information given to the examining committee. And the court said no, said we're not going to give those to the examining committee. Yes, there is this so-called procedure, which I would say is really no procedure at all. Was the court inviting me to rehear what I had just asked the court to provide the committee? I don't think so. I didn't read it that way. It was like, well, if I have something else I'd like to offer, I could come back. But I didn't read it as, so in an abundance of caution, yeah, I have filed a motion because I'm not sure what the court was thinking after it said, no, you can't give this to the committee. And I'm entering an order appointing the committee, who has 15 days to do their work. The order was not available to the committee. Only that standard order was available. The committee had no idea that there was this procedure, so to speak, where they could obtain additional information. They were kept in the dark about that. They were kept in the dark about the verified petition that was filed, and they were kept in the dark about medical records. I heard counsel say, well, the committee could have just looked up who filed the petition. No, they couldn't, because his co-counsel below asked that the court file be sealed. I did not see that as I should be aware that now the committee never gets to see it. It goes without saying, I've always understood that the committee sees the petition. So they sealed the file. Counsel said he could have looked it up, but I don't know how he could have looked it up and made that phone call. And so the order was not available. The petition was not available. The Wallace Court found jurisdiction. The original reports, I find also to be an offensive practice for an attorney to go tell their client, you just don't show up for those court-ordered exams. That's what happened. And that's wrong. And the committee that was appointed should have been made aware that this person refused to show up for exams, because those are questions they should ask that person more about. And so in its totality, we asked for instructions. The court said, no, you can't provide the caregiver notes and the emails. And so that's why we had to file this appeal. And the jurisdiction, I believe, is there.
All right. I don't know if you're able to hear my little timer bell, but it just went off. So I want to thank you. Thank you both. And thank you both for a well-argued case. And thank you for appearing in our remote OA. And with that, the court will be, this is the last case on the court docket. We'll go ahead and conclude the docket at this time. Thank you all. Thank you, Joe.
So,
Thank you, Mr. Oscar.
Thank you.
You're supposed to leave.